Okay, thank you. And I have consulted our legal department and looked at the rules more closely as well. Mr. Tapia, I have two subpoenas here. One was for Antonio Aragon. That looks like that was served on April 11th, yesterday's date. And I see that it's notarized and the return of service is there. And then I see the other subpoena for Zane Aguilar. That was served on April the 8th. I see it's notarized as well. And there's also a note. It says refused service. So I don't know whether anything was handed to Mr. Aguilar or not, but that's kind of a side issue. What I was looking at, because of those dates, I was looking at notice requirements. So, you know, today is the 12th. The 8th was only 4 days ago. And then one person was served or attempted to be served on the 11th, which was just yesterday. So if we look at Rule 7606, and you might have statute books there in front of you. Both of you can look at the statute books if you want to. There's one statute book on your table, Mr.
I have it on my
Okay, and so statutes, or the rule number 7606 on subpoenas, if you look at Section C, protection of persons subject to subpoenas, look at C2, look at B. It says here, subject to subparagraph D2 of this rule, a person commanded to produce and permit inspection and copying may, within 14 days after service of subpoena or before the time specified for compliance, if such time is less than 14 days after service, serve upon all parties written objection to inspection or copying of any or all designated materials or of the premises. If objection is made, the party serving the subpoena shall not be entitled to inspect.
That goes to under Rule 1037. When you serve a subpoena, deuces take 'em, it has to be done 30 days before the 30 days before.
Okay, well, this is 14 days, and this is for protection of persons subject to subpoenas.
No, it says within 14 days after service of the subpoena. So you give him 30-day notice, he only has 16 days to object.
So I guess, okay, so that's what I was looking at, trying to locate in the rule when a subpoena should be served, and after consulting the legal department, well, that was the section they referred me to, but my concern is that defense counsel is asking the court to enforce subpoenas that were not given very much notice to individuals to appear. The 8th was only 2 business days ago. 8th, 9th, 10th, 11th, 12th. Today's the 12th, right? Or is it the 13th? Today's the 12th, so it's only 4 days, 4 calendar days, and really only 2 business days of notice. And then if one was served yesterday, that's not even maybe 24 hours notice to appear. So,
just for the record, Your Honor, they were both contacted 2 weeks ahead of time, Mr. Aguilar, and he told us about the death and that he may not come.
Okay.
So however,
but you're asking the court to enforce these subpoenas with the dates of service that are noted on here. That's what I'm relying on. I'm not relying on some other form of communication or notice. When you serve somebody with a subpoena, you're serving, you know, this is your request to have them to appear in person, but there has to be adequate notice. 1 day notice to appear for a legal document, and asking the court to enforce this is not fair to the person who was served, because that's not, I can't find that that's adequate notice, especially for one being served just on yesterday's date. And then the other one that was served on April 8th, that's, like I said, that's only 2 business days ago and 4 calendar days. I'm going to find that these are, there was insufficient notice given to these parties to require them to appear in person. for subpoenas for police officers to appear for just simply a pretrial interview, there has to be 14 days notice. And we only have 4 calendar days on one and maybe 24 hours for the other. So I know defense counsel is asking the court to enforce these. I didn't ask in what manner defense counsel wanted the court to enforce these, but without sufficient notice, I'm not going to get to that issue because I can't, I mean, at least if there was 5 business days, that would be something, but we don't have at least 5 business days of notice for either of these witnesses to appear. So it wouldn't be fair for me to issue a bench warrant or something like that to these individuals if they weren't given sufficient notice.
Oh, we don't want that. We don't want that. There's still work with Ms. Carlton. But the issue is I'll take it up with my process server. GK brought them and she only served them yesterday.
Well, one was served yesterday and one was served Friday, and today's only Tuesday, right?
Right.
So it really isn't fair if the court was going to enforce these in some manner by either holding them in contempt,
well, we
issuing a bench warrant.
Do you want a continuance?
I'm going to give these back to you, Mr. Tapia.
Okay. We'll finish it up today, Your Honor. We don't want, we'll withdraw all our...
Okay, so there are those subpoenas. And so at this time, the court will hear closing arguments. Since this is the state's burden to prove, I will hear from the state first, and then I will hear from defense, and then the state gets the last word. Okay, Ms. Sanchez?
Thank you, Your Honor. In conclusion, the city proved that Ms. Carlton is the property owner of 518 Valencia Drive Southeast by her own admissions and through the public record of the county assessor's office. Additionally, Ms. Rowley testified that she found remodeling work done at this property without a building permit, and Ms. Rowley did properly inspect the property with Ms. Carlton's consent. Ms. Carlton did admit to work done without a permit, and Ms. Rowley has testified that there still is not a building permit on this property. Under the Uniform Administrative Code, each day of a violation is a new offense. And for these reasons, the defendant should be found guilty in this case. I would like to state that typically the city's interest in these misdemeanor cases is not to punish the property owner. We are seeking compliance. I would request Ms. Carlton, if she is found guilty, not punished to jail time, we would like to perhaps impose a fine if found necessary and a requirement to obtain the necessary permits for the work done. Thank you.
Thank you, Nicole.
And
thank you.
let's hear from defense.
Your Honor, briefly, we believe that there is no scienter, no proof of motive in this matter, that this being a petty misdemeanor, that it should have gone out pursuant to the rule stating that they had to be filed within 1 year. Presented evidence of the work being done 5 years before, and I don't think the court has jurisdiction to impose a sentence or to conclude a guilty plea in this matter. I think that there is confusion of what a reasonable person could understand when the court looked at the rule, 2018 rule and code, that there is different codes within that code that apply. The court didn't allow me to get into it, but the 2015 International Code states that there is, as I made him an offer of proof, an opportunity not to require building permits for certain work. And I believe that Ms. Carlton, in hiring and having her business, hiring people that do competent work, it shows that through everybody that testified that they are licensed, their burden is to get permit. It's okay for the city to come and get the landlord, but that's when they show intent on the landlord of trying to circumvent the rules. She had people that are licensed by the state of New Mexico performing the work, and maybe that's the customary in the business. They don't get permits. I don't know. This is my first time I've done a building permit case, but I think that there's sufficient grounds for the court to find that there has not been proof beyond a reasonable doubt that there was intent to violate the the ordinance, and then Ms. Carlton should be found not guilty.
Thank you. State, you get the last word?
I don't have anything additional, Your Honor. Thank you.
Okay, thank you. Okay, parties, I've taken pretty extensive notes. I've listened very intently to all of the witnesses, to Ms. Carlton as well, and I take notes so I can go back and refer if I need to. But what I've been looking for is for specific information about whether defense did in fact have a permit that was unknown to the city, whether any of this work was permitted, and I have not heard anything to that effect by from Ms. Carlton directly, and I actually heard her admit that she did not get permits. I'm going to look at my notes. Carlton was asked whether specific work was done on the remodel of this home. She admitted that remodeling had been done. She admitted that new windows had been installed and that there was a new roof put on, and whether there were new water heaters installed. She admitted that all of that work was done, and as well as new plumbing that was done. And she was asked whether she had applied for any permits, and she stated no. And so by Ms. Carlton's own admission, she stated that she did not have permits. I'm hearing that defense's argument is a couple of different things. First of all, I've heard that the argument already before that the Uniform Administrative Code of 2015 does not apply to this case, that instead the International Residential Code of 2015 should apply, which I've already made a ruling on that, and the charging document, specifically the criminal complaint, refers to Section 109.1 of the 2018 City of Albuquerque Uniform Administrative Code. And so I've already made a ruling on that. Defense counsel is also arguing that it was the responsibility of the contractors to get the permits for the building. For building and those alterations and repairs and anything installed on the property was the responsibility of the contractors and not of Ms. Carlton. I haven't heard or seen any case law cited as to that argument that would support that argument. But the Section 109.1 states, let me pull it directly from the code instead of reading it from the complaint. Section 109.1 states, except as specified in Section 109.2, no building structure or building service equipment regulated by this code and the technical codes shall be erected, constructed, enlarged, altered, repaired, moved, improved, removed, converted, or demolished unless a separate appropriate permit for each building, structure, or building service equipment has first been obtained from the building official. All re-roofs require a permit and inspection. And then there's some exclusions under Section 109.2.1, but those did not apply in this case. And there was no testimony that the work that was done was in those 109.2.1 of that section. So again, there was an admission from Ms. Ms. Carlton that she did not get permits. When we heard witnesses testify, Mr. Gutierrez and Mr. Carr are very nice gentlemen, very hard work. They seem to be very hard workers, but Mr. Gutierrez at least couldn't answer any questions about permits and whether they were, he didn't really know whether they were needed or not either. Give me 1 second here. I'm going to refer to some notes. Mr. Carr stated he did not get permits, and he didn't know of any permits that were needed. And so to me, he didn't seem like he had knowledge about permits. So that was, he just didn't seem to have knowledge about permits based on what he testified about. And Mr. Gutierrez was asked if he got a permit. He said no. When he was asked why, he said because he had started with patchwork and then so he didn't need one then. Then it went on to a full roof replacement, so he never got a permit. And his answer was, he said that it was his duty to get a permit, but he seemed very hesitant when he answered that question, whether he really knew about permits or not. And Mr. Tapia made somewhat of an argument that he doesn't know whether that's customary or not for these workers to get the permits or not, or maybe not to get the permits. So with the information that I have in front of me, and based on the code, testimony by witnesses, as well as Ms. Carlton, I'm finding, Ms. Carlton, that you are guilty of building without a permit. Again, I haven't heard any case law that would transfer that responsibility to the contractor specifically to get the permits. I would have considered any argument if there was case law presented to the court that transferred that responsibility to the contractors and not the homeowner, but I haven't heard that. So I am finding you guilty of building without a permit under Section 109.1 of the 2018 Uniform Administrative Code. What I would do now then is I would probably set this aside for sentencing, and I would ask both of you, I'd probably reset this for sentencing in about 30 days, and I would ask that you submit recommendations for sentencing to the court, and then I can make a determination of what I believe. Just give the court some time to think about it, maybe give the city some time to think about what they're wanting, and maybe whether it's in more detail or not, or maybe it'd be the same as today, but at least it would give me some more time to think about what a proper sentence would be. Mr. Tapia, you could also make a proposed sentencing as well, a recommendation as to sentencing, and I'd be glad to hear. I would prefer to have that in writing at least 2 weeks before the sentencing date, so that both of you can see what each other is recommending, and the court can review that as well. Yes, I'd say 2 weeks before. So why don't we just set some dates so we can give deadlines? Let's reset the sentencing. Today is April the 12th. Let's reset sentencing for the 17th, May 17th? Okay, let's reset sentencing for May 17th. Let's do it in the afternoon. Or what time did you have? Okay, we can, what about 10:15 on May 17th? I would want recommendations no later than May 3rd. If you all are going to make proposed recommendations. May 7th. Well, we can move it. What about the next day, May 18th? Or the day before even? Even sometime that week would be fine with the court. What about the 18th, what time? Okay, the 18th at 10:15? Okay, so we'll set this for May 18th at 10:15. I would want your written recommendations for sentencing, no later than May 4th. I'm not going to have probation do a pre-sentence report. I don't think that's necessary unless the city is requesting that. Okay, I would rather just hear recommendations from both sides as to what you believe the sentence should be. And then the court can make a determination after I've reviewed that and kind of thought over the case. And I would like some time to think about that and let you all make recommendations. Mr. Tapia, is there anything else? Okay, and Ms. Carlton, I'm going to enter an order finding you guilty of this charge, and you have 15 days to appeal my ruling. You would be able to have a de novo trial in district court, and you have 15 days to appeal. So I would grant you an ROR appeal bond, just so that, actually today isn't sentencing. No, it's not sentencing. On the date of sentencing, you would have 15 days to appeal. So we're not sentencing today, but typically right after a trial, I give the defendant the information that they do have the right to appeal. But you'll have 15 days from the date of sentencing to appeal, and that would be on May the 18th. You'll have 15 days from then to appeal. Okay, anything else, parties?
In the city, thank you.
Okay, I thank you both, and take a break so we can all get lunch or something. It's been a long morning, so thank you for your time. And if you need anything from my clerk or any questions, you can ask her. I'm gonna take everything back with me, and I'll back there. Actually, I don't need to. I'm just gonna put notes in the file. So, and then I'll have Erica bring it to you, or something. Okay, thank you all. Have a good day.
I got it. Stay, guys.